Hi, my name is Ben Freer. I am a U.S. business immigration lawyer. In my practice, I get a lot of questions about the E-2 visa investment. And one question that I commonly hear is, can I use a loan from a family member for my investment? And the answer is yes. Yes, you can. However, there are some things that you and your gracious family member need to know about using a loan for your qualifying investment. First of all, you should know that as an E-2 visa applicant, the source of your funds will be scrutinized. The U.S. government is concerned about illegally obtained money being used to open businesses in the U.S. Therefore, you will have to clearly show where your money came from during the E-2 visa application process. Now, many of my clients will do this by showing that their money came from the sale of a business. Others will use tax records to show that they earned the money through employment. And in the case of a personal loan, you will have to show that the origin of the lender's money was lawful. This means that family members who loan you your money for your E-2 visa investment will be subject to the same scrutiny that applies to you as the principal applicant. This raises the question, is your family member comfortable with all this? They likely think that they're already doing you a huge favor by lending you the money. Perhaps they value their privacy. Maybe they feel that it is demeaning to have to prove that their money was lawfully obtained. Whatever the case may be, you'd be wise to discuss these realities with your family members at the beginning of the process. Let them know that they will be scrutinized. Make sure they're okay with that. You don't want them to tell you that you can have the money and then back out later when they realize what is involved in making the loan. Now, in addition to demonstrating the source of the loan funds, you'll also have to make sure that your loan is permissible for E-2 visa purposes. Now, this loan can be unsecured. It can be secured by your personal assets. However, it cannot be secured by the assets of the E-2 business. It's very important to understand that. Another issue arises if the money that is being used for your E-2 visa investment is in a jointly held bank account. Anyone who applies for an E-2 investor visa has to demonstrate that they are the person that has possession and control of the funds that are being used to establish the business. A consular officer may question whether money held in a joint bank account is under the sole control of the applicant. In order to avoid confusion, a lot of people in this situation take some additional steps. For example, you could have the joint owners confirm in a sworn affidavit that their interests in the funds are intended to be a gift or a loan. This could clear up any possible confusion and avoid a delay or a denial. Now, hopefully this general information was helpful. Loans from family members can be used as E-2 visa investments. However, there are some issues that you need to be aware of before utilizing such funds. This is best accomplished by working with a knowledgeable immigration lawyer who can help you avoid unnecessary headaches during your E-2 visa journey. Thank you very much for watching, and please feel free to reach out to me if you have any questions.